Cornwell, you weren't subpoenaed to appear here today, were you?
No, I was not.
So you voluntarily appeared?
At the approval of my board of directors, yes, I did.
To help out Mr. Maier?
I came here as a person of interest of the statute being interpreted the way it should be interpreted.
Who requested that you come here and testify today?
A letter was sent to my board of directors from Sheriff George Maier asking my attendance at this meeting today.
And that's why you're here?
As my board approved, yes.
And during the course of the quo warranto action that Mr. Maier lost, you had multiple conversations during pendency of that case with Mr. Rosenberg.
Yes, I did.
What did you all talk about? As far as, I don't mean the weather or the Cleveland Indians baseball pennant or something else. What did you talk about as far as the quo warranto action?
We talked about our position as an association that we have taken in past cases where we have filed an amicus curiae brief. In those cases where we have asked the Supreme Court to read the statute as it reads, and that's how we prepare our amicus briefs.
And your organization did in fact file an amicus brief in support of Mr. Maier in the Swansea quo warranto action?
I believe if you look at the amicus curiae brief, you will see that it was filed to ask the Supreme Court to interpret the statute. It was not filed on behalf of or in support of.
In fact, in the amicus brief, didn't you join in the brief of Mr. Maier?
I believe we, and I'd have to go back and look at it again, but I would have to look and see. I'd have to go back and look.
You don't recall?
Don't recall.
And in that brief, you essentially argued what is on this board today. Mr. Maier meets all these qualifications.
Correct.
And the Supreme Court said you were wrong.
The Supreme Court decided that there was no definition of full-time, and at that position, they said that they did not qualify under the full-time criteria that they established as either 80 hours or 40 hours. And
through your brief, you argued that he did meet that full-time
criteria. Yes, because at that point in time, there was no definition in the statute under 31101, nor was there any used in any previous Supreme Court decision what full-time was defined as.
I'm not asking you to explain why you lost. I'm just saying the Supreme Court did not, for want of a better term, buy your argument. Your argument was rejected, that he met this full-time qualification. The Supreme Court said, no, he doesn't. Isn't that what happened?
The Supreme Court ruled that he did not meet the qualification. That is correct.
You understand, of course, nobody in this room needs to like it, but that's what the Supreme Court said.
The law of the land.
So you're testifying here as an expert, and you've already been wrong in the same manner, right?
And I believe you are too.
I'm not testifying. I need you to answer my question. You're testifying as an expert. Over my objection, you're testifying as an expert on the construction or interpretation of this statute. Is that what you're doing today?
Yes, I am.
And when you made an argument as far as the full time before the Supreme Court disagreed with your position.
What the Supreme Court, and my understanding of what the ruling was, is the Supreme Court defined what full time meant. It had never done that before. So our argument was valid at the point that we made it.
So you're saying Mr. Maier won the Supreme Court case?
Objection.
Wait, so the argument's valid?
He answered your question.
Given your history of being involved in the legislation about sheriffs, this 311.01, how long ago did you say you started your involvement with the association?
I was hired by the association in September of 1983.
So you're familiar with the fact that the current version of the statute, this B9 that refers to rank, B9A, I'll call it, 2 years of supervisory experience as a peace officer at the rank of corporal or above. You, of course, know the statute didn't used to say that. didn't mention
Yes, I
rank.
did not mention rank. That is correct.
Did not mention rank.
That's correct.
In fact, I'm reading from a Supreme Court opinion I've already cited to the board, and I'll give you and counsel a copy on oral argument. But it's a State Ex Rel. Wolf with an E on the end, Delaware County Board of Elections. I'll just give you the electronic site, 2000-Ohio-295. The court actually goes out of its way at footnote number 1 and quote,
Objection.
Former.
Objection. Legal argument for later, questions for now.
No, I'm reading it so he can construe it. He's been touted as an expert who was involved in these legislative changes. That's what I'm doing. Okay. I don't get the latitude. Go ahead. Okay. Former RC 311.01B9 provided that no person is eligible to be a candidate for sheriff unless that person has, quote, at least 2 years of supervisory experience or its equivalent. But you're familiar with that General Assembly, perhaps part of your group's lobbying, changed that to its current version.
That is correct.
You know that, right?
Yes, sir, I did.
And the current version doesn't use the term equivalent when it comes to this notion of rank of corporal, does it?
No, it does not.
And have you ever been a police officer yourself?
No, sir, I have not.
Are you an attorney?
No, oh, sir.
You say that like it's a bad thing. I mean, don't hold it against me just because of, because of Rosenberg, for instance. I'm just looking at 9A, and it uses this term rank of corporal. Isn't that a paramilitary designation when it comes to police officers?
In law enforcement, it is paramilitary.
And so a lot of police agencies, municipalities, townships, sheriff's departments, they have this paramilitary rank, corporal, sergeant, major, captain, colonel. Right, it's kind of common in the paramilitary police business, so to speak.
Sort of common.
And this directorship, this assistant director of public safety, and I think for a couple days, Mr. Maier was director of public safety.
I believe that is true when Director Guzman stepped down and he was appointed as the new, I believe.
Isn't that a civilian position?
No, it's
The director?
It may be filled by a civilian, but there are people that have been in other capacities, law enforcement capacities, former state superintendents of the State Highway Patrol have been in those capacities, former prosecutor from Summit County was in that position.
So there's no requirement for that assistant director or director position to actually be a peace officer certified by a PATA, is there?
And nor does it state in statute that they have to be for the directorship.
That's what I mean. I guess you answered the question a little differently. There's no requirement.
To be the director? No, there is not.
Okay.
But they
And
are
so-
supervisory in nature.
So you could be a peace officer, you could not, but it's not required.
Asked and answered.
That's his job then, object, not yours.
I've answered it 3 times.
Okay, well, I'm sorry, I was just wanting to get clarification because I'm confused by your testimony. The Buckeye State Sheriff's Association, is it a government entity?
They're not for profit.
So it's a nonprofit private corporation.
Correct.
Is a membership somehow lawfully required?
No, it is not.
Do all 88 sheriffs belong to your organization currently?
Currently, yes.
And has that generally been the case for quite a while?
For quite a while, yes, it has been.
No other questions. Thank you, Mr. Chairman.
If I may?
Yes.